Okay, let's get started. Okay, welcome everyone, and thank you for joining us virtually this morning for what we hope will be an informative presentation for landlords in the city of Richmond. My name is Monica Bejarano, and I am the Rent Programs Administrative Aide for the Public Information Unit. Rent Program Services Analyst, Magali Chavez, will be conducting this morning's presentation. Before we get started, I would like to share some logistical information. Please note this presentation has been posted on the website at richmondrent.org/workshops for your reference. Please also note that this presentation is being recorded, and we hope to post the recording on our workshop page as well. If you have any questions on a particular topic discussed today, we ask that you type your questions into the Q&A function on the bottom of your screen, and we will address questions at the end. Without further ado, I would like to introduce Magali Chavez.
Good morning, everyone. Thank you for being with us today. Monica, can you allow me to share the screen?
Yes, you are the host now.
Okay. Can everyone see? You can see it?
Yes.
Okay. Okay, so let's begin. Like Monica said, my name is Magali Chavez. I am a Rent Program Services Analyst, and I'll be giving today's presentation on handling habitability in the city of Richmond. So before we begin, we wanted to do an important update to let everyone know that there is a new state law. It's the COVID-19 Tenant Relief Act. It was signed by Governor Newsom on August 31st, 2020. The act provides that residential tenants who are unable to pay rent during the COVID-19 emergency cannot be evicted for rents that became due between March 1st and January 31st, 2021, if certain requirements are met. So the act's eviction protections apply only where the evictions are based on non-payment of rent. So under the COVID-19 Tenant Relief Act of 2020, landlords may not evict tenants for non-payment of rent that became due between March 1st, 2020 and August 31st, 2020, if the tenant returns a declaration of COVID-19 related financial distress to the landlord. You can access the declaration of COVID-19 related financial distress at the following link, but the forms and information is also on our website. Further, landlords may not evict tenants for non-payment of rent that became due between September 1st, 2020 and January 31st, 2021. If the tenant returns a declaration of COVID-19 related financial distress to the landlord and pays 25% of the rent due by January 31st, 2021. In addition, tenants must provide a declaration for every notice of termination of tenancy for non-payment of rent that they receive. In either case, tenants have until the expiration of the notice of termination of tenancy for non-payment of rent to return the declaration of COVID-19 related financial distress. And in the event that no notice is issued, tenants are still encouraged to send the declaration to the owner to let the owner know or the landlord know that they are facing COVID-19 related financial distress. So to kind of recap, the owner would serve the tenant a 15-day notice to pay rent or quit as required under this new law. With that 15-day notice, the owner has to include a declaration form of tenant-related financial distress, and the tenant has until the notice expires to return that notice. If they do so, the landlord cannot evict the tenant for non-payment of rent between March and August 31st. And then in addition, after August 31st, from September 1st to January 31st, 2021, in addition to the declaration form, the tenant also has to pay 25% of the rent by January 31st. So you're encouraged to visit our website, richmondrent.org. We have an FAQ page. We also have the forms that you need. So we have the termination of tenancy, the 15-day notice to serve to the tenant, and also the links to the declaration form. So you're encouraged to visit our website for that additional information. Okay, with that being said, let's move forward with the actual presentation. So some of the topics that we're going to cover today is the purpose and overview of the ordinance, the properties covered under rent control, and exempt properties. This is going to be an important topic moving forward, especially with issues related to habitability, the state law that governs habitability, recommended steps and options for handling habitability, how tenants can petition the rent board if a landlord is not complying with the implied warranty of habitability, required relocation payments under the Richmond Ordinance, the Richmond Relocation Ordinance, habitability problems and evictions, landlord entry under state law and collecting the rent or inability to collect the rent, and lastly, breach of the lease and options for mediation with the rent program. So let's begin. The purpose of the rent ordinance, right, also known, the official title is the Richmond Fair Rent, Just Cause for Eviction and Homeowner Protection Ordinance, as you'll hear us call it, the rent ordinance. It's really to promote neighborhood and community stability, healthy housing, and affordability for renters in the city of Richmond. And it does so by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law. We're also trying to ensure landlords a fair return. So the Richmond rent ordinance is really broken down into two sections. The first section is a rent control section. What this means is that rents are regulated, and you'll hear the term the maximum allowable rent. So the landlord is allowed to charge the maximum allowable rent. And this is done by calculating the base rent, plus any annual general adjustments that the landlord is entitled to, and also any allowable individual rent adjustments that are ordered by the hearing examiner through the petition process. And so the petition can have an upward or downward rent adjustment. So the base rent is the rent in effect as of July 21st, 2015, if the tenant was there at that time, or the first rent charged for tenants that moved in after that date. So if I just moved in last month, my base rent would be what I was paying as of October 2020. The annual general adjustment is also known as the AGA, is 100% of the consumer price index in the Bay Area, and it's essentially the inflation rate of the Bay Area. And then lastly, the petition process, which we'll discuss further today, is really a mechanism to increase or decrease the maximum allowable rent, or the MAR, based on the reasons permitted by the rent ordinance. So either a tenant can file a petition or a landlord can file a petition. So that's one section of the ordinance, which is rent control. The other section are just cause for eviction protections. We won't really be discussing just cause for eviction protections in a lot of detail today, but just to go over it, not all properties, there are properties that are protected by rent control and just cause, and there are properties that are only protected by just cause for eviction. But essentially, just cause for eviction protections means that a landlord needs to have one of the 8 just causes to terminate tenancy. And there are a little bit of nuances right now because there is a Contra Costa County order that prohibits some of these termination of tenancies. And like I mentioned, there's a new state law that currently governs non-payment of rent. So things are a little bit different right now because of the pandemic, but under the rent ordinance, there are 8 just causes. It's failure to pay rent, breach of the lease, nuisance, failure to give access. And so these first 4 are what are called at-fault evictions, meaning that the tenant is doing something to produce an eviction. Then there is temporarily vacate in order to undertake substantial repairs, and owner move-in, withdraw from the rental market, also known as the Ellis Act, and temporary tenancy. And these last 4 are considered no-fault evictions, meaning that the tenant is not doing anything wrong, but for those specific reasons, the ordinance allows owners to take possession based on that just cause. So those are the different 8 ones. We'll cover some of them in more detail, but if you do want to get more information about the just causes, we do have a previous workshop that we did, or you're encouraged to contact the rent program. So moving forward, one of the topics that is important today for discussing habitability is the maximum allowable rent as it pertains to rent-controlled units. So the MAR is a maximum rent that can be charged for a controlled rental unit. So think of the MAR as the rent ceiling. A rent increase cannot exceed the maximum allowable rent, but it can be less. Even if the maximum rent is not charged, the maximum allowable rent remains the same. And the landlord may choose to raise the rent to the maximum in accordance with state law and the rent board's banking regulations, or they can decide a year that they don't take it, their MAR will remain the same, and then they'll have to catch up at another time. And so to repeat this over, because it is an important topic, the maximum allowable rent equals the base rent plus the annual general adjustments, the AGAs, and any individual rent adjustment that is made. The petition process is part of the MAR, but that's like an exception of the MAR. Usually the MAR will be the base rent plus the annual general adjustment to simplify it. So it'll be what the tenant was paying on July 21st, 2015, or if they moved in after that date, what they paid their first, the date that they first moved in, plus any annual general adjustments that they qualify for. So it's important to understand which properties are covered by the rent ordinance and how the type of property is impacted. So first, there are what are called fully covered or controlled rental units. And these are properties that are under rent control and just cause for eviction protections. And typically these are properties, multi-unit properties built on or before February 1st, 1995. So you know, how many living units are on the property and when was it built. Then there are what are called partially covered properties, and these are properties that only have just cause for eviction protections. There are no rent control protections. And these are typically subsidized units, which include Section 8 tenancies, properties with one dwelling unit on one parcel, which I think the common term is single family homes, condominiums. There's also new construction, which is property that was constructed after February 1st, 1995. And then this rule applies to Costa-Hawkins, which requires units to be permitted with the certificate of occupancy. So permits are final, and the unit has to be fit for residential habitation. And then lastly is fully exempt properties. These are properties that have no rent control and no just cause for eviction protections, meaning they're fully exempt from the Richmond Rent Ordinance, and the rent program would not deal with any administrative processes with the property. And so these are properties where the landlord and tenant share a kitchen and or bath. Also single family homes where a permitted ADU was added and the main house is owner occupied. And lastly, retirement homes. So one thing that I do want to say about the single family homes where a permitted ADU is that the key term here is permitted. So if there is a property where the owner lives in the main house and they have an ADU in the back, but it's not permitted, that ADU is most likely going to fall under fully covered properties. So depending on how the unit is permitted or not permitted, it impacts its applicability on the rent ordinance. So it's the analysis changes a lot based on some key details. So if you always have any questions, it's encouraged for you to contact the rent program. Okay, so let's get started on the state law governing habitability. So I think this is an important topic to cover and to understand. So the idea is that implied in every California residential lease is what is called the implied warranty of habitability. This law requires that a landlord provide rental units that meet certain standards for habitability. This law is also known as the implied warranty of habitability, and it has been codified under several statutes, but it's mainly under California Civil Code 1941.1, which will go in further detail, and Health and Safety Code 17920.3. And so let me just kind of back up. So the general idea is that landlords are responsible for maintaining a minimum standard of living for tenants, right? And that minimum standard of living, or that implied warranty of habitability, is included in the rent that the tenant is paying. So the tenant is paying their rent, and part of their rent that they're paying includes the implied warranty of habitability. So California Civil Code 1941.1 kind of lists has very specific details that the owner needs to follow on what is considered a habitable unit. So landlords must provide rental units that are habitable, in a habitable condition and fit to live in. A dwelling unit should be untenable, or for purposes of Section 1941, if it substantially lacks any of the following affirmative standard characteristics. So there's quite a few, right? So some of them are effective waterproofing and water protection, plumbing or gas facilities that conform to applicable law, heating facilities. So there's several different ones. I'm not going to go into every single one, but that's the idea, that there are specific state laws that kind of govern and stipulate what a landlord needs to have, or what the unit needs to meet, for the unit to be considered habitable to live in and meet that implied warranty habitability. And if some or a few of these stipulations are broken, then the owner is not keeping that promise of the implied warranty of habitability. Likewise, tenants also have responsibilities to meet under California Civil Code 1941.2. So there's no duty on the part of the landlord to repair a dilapidation if under Section 1941 or 1942, if the tenant is in substantial violation of any of the following affirmative obligations. So the idea is that tenants also have a responsibility to maintain the unit and to upkeep with specific things, right? And so it's provided that tenant's violation contributes substantially to the existence of the dilapidation, or interferes substantially with the landlord's obligation under Section 1941 to effect the necessary repairs. So this can be to keep the part of the premises which the tenant occupies and uses in clean and sanitary conditions, to dispose of the dwelling unit of any garbage or waste, and to keep everything in a sanitary manner. Another one is that they're responsible for the people that they bring in, right? So not to permit any of their guests or any persons on the premises to cause any damage to the property, or remove any structures or part of the dwelling. So again, there's several different details that you can go over. So to move forward, understanding the implied warranty of habitability, these are the recommended steps for addressing habitability problems. The first is to contact the rent program to become informed about your rights under the Richmond Rent Ordinance, and to understand your responsibilities. So I think, being in this workshop is a key step, understanding how the Richmond Rent Ordinance works, and what is the applicable state law in a given situation. Another important step is to document the problem, document it as much as possible. So write letters in response to any complaints, keep signed copies, and consider proof of mailing. So tenants are always encouraged to document the issues. Likewise, when you receive any type of complaint or any type of notice letting you know of a habitability issue, make sure that you're documenting your responses and documenting the issue. So with that, take photos or videos of the problem and attach them to letters of complaint. So make sure you have everything, accessible to you at all times. So it's important to know that if you as a landlord are non-responsive to complaints, the tenant may schedule a housing inspection with the Richmond Rental Inspection Program. Tenants who reside in subsidized housing, such as Section 8, may contact the housing authority to schedule an inspection. So understand that if a landlord is not complying, there are different avenues that the tenant has to document the inspection or to get the landlord to comply. So if the property is fully covered under rent control, a tenant also has the option to file a petition for rent reduction. If the property is fully or partially covered, the tenant or landlord have the option to request mediation services. So that's another service that's available through the rent program if there are habitability issues. Filing a petition for rent reduction and mediation services are available through the rent program, so you can contact the rent program and understand how the petition process works, or if you are interested in mediation, make a formal mediation request in writing. It has to be put in writing for the rent program to get involved. So in more detailed tips for documenting habitability problems. And so, like I said before, because tenants are advised to document their habitability complaints, landlords should respond within a reasonable time to determine the situation and what may be required for you to do on your part. So attaching photos or videos to the letter or email is an effective way to document the problem. And also expect these complaints and communications and keep copies for your own records, right? So I think it's always a good idea for a tenant to put any request or issues of habitability in writing. That way it's documented and there is evidence and proof of the issue. If you are engaged in verbal communication with the tenant, so if the tenant calls you and complains over the phone, it is recommended that you summarize the conversation in writing to avoid unnecessary disputes or misunderstandings. So it's always really important to have everything documented. Even if there was a conversation over the phone, it's suggested that you memorialize it through an email or write a letter, summarizing this is what we discussed, these were the issues that were discussed, and this is what you believe needs to be fixed. Again, if the landlord is not responsive to legitimate complaints, the tenant may consider documenting the habitability problem through an inspection by the city. And so that the city can compare the landlord to fix problems. So sometimes when tenants call and, they've been notifying the landlord that there are habitability issues, but the issues haven't been addressed, they can request an inspection with the residential rental inspection program, or with an inspector with the city. An inspector can go out. Sometimes notice of violations are issued, which kind of is like a notice saying the city is compelling you to fix these problems within a expected amount of time. So understand that is a consequence, that if, when the tenant is notifying you of issues that is not being addressed, then there are other agencies that might get involved if the issue continues. So using a chronological approach to memorializing the problem is important in framing the narrative. In the case that a petition is filed or the issue goes to court. So that's why it's also super important to always memorialize everything, document everything, and make sure that it's in a chronological order that's easy for someone else reviewing it to understand. Also, be mindful that anything you write may become part of a court action where you would be required to appear before a judge to explain your complaint. If it's not a judge, it's a hearing examiner. So in other words, you may hurt your credibility if your letter or email makes you seem unreasonable or abusive in tone. So, right, it's always recommended that you speak in a professional and courteous manner in your letters, in your formal writings. Okay, so requesting a housing inspection. So to request an housing inspection, you can contact the City of Richmond Residential Rental Inspection Program. Their phone number and email is provided. Another avenue is landlords can also contact the Richmond Rent Program and to speak with the housing counselor and request a referral for an inspection there. So if you were to speak to me, I can send an email to the building and planning department or to an inspector, saying that either landlord or tenant is requesting an inspection. For Section 8 tenancies, if the landlord wants to request an inspection for a Section 8 tenancy, they can contact the Contra Costa County Housing Authority, and the number is provided there. Once it's determined that an inspection is needed, it generally may take up to 10 days after making the request for an inspection to take place. So usually when a landlord or tenant contacts the department, either the rent program or there's a residential rental inspection program or an inspector, a case is opened. So an email or whatever documentation is made notifying that a request has been made. it then gets assigned to an inspector, and then depending on the inspector's availability, they'll go out and inspect the property. So, that can take several days. The inspector will notify the landlord if code violations are found. So this is where I was saying that if an inspector goes out, sometimes notice of violations are issued. And so as the owner, you may face fees or fines for failure to correct the violations. So understand that once other agencies are getting involved, that there are other consequences that you may be facing. These include fines or different violations that are issued to you. So this is the criteria for filing a petition. So another avenue that tenants have if a habitability issue is not complied with, right, is to file, and this is specific to rent controlled units, right? So it's important to be aware that tenants who live in fully covered rental units can file a petition for rent reduction if they believe the landlord is not upholding the promise of the implied warranty of habitability. And so a tenant can petition to reduce the rent if the following criteria is met. So 1, the landlord has been informed about the problems. 2, there is a decrease in habitability or reduction of space or services. So a good example of this is for habitability issues, sometimes, mold, right? So there's a reduction in habitability in the unit. I have had cases where the mold is so bad that a tenant can't use the room, right? So like if the mold is covering their bedroom, like it's all over the walls, it's all over the floor. So the tenant has a good argument to say like, well, there's a reduction of a bedroom. There's a reduction of space. I can no longer use that bedroom. And similarly, if there's a reduction of services, usually this relates to garbage. So if there's like overflow, the tenant can argue that they don't have access to that service. But be aware that these are things that the tenant can petition for, that there is an avenue for rent controlled units that they could file a petition through the rent program. And so in order, tenants have to be under rent control, which these are properties that are multi-unit properties built on or before 1995, which are defined as fully covered or controlled rental units under the Richmond Landlords. So those are the units that are entitled to file a petition. And so also understand that filing a petition may lead to a hearing. So the petition process, I think, is similar to a court process, but it's an administrative in nature. So a tenant would file the petition for habitability problems with the rent program. It'll get reviewed. When they file the petition, they also have to serve the landlord. Once a petition is deemed complete, then the owner is notified and they have a right to object to the petitions, and eventually it leads to a hearing. So after filing the petition, right, the landlord and tenant or the representatives are required to attend a hearing where both parties can present their evidence. Alternatively, the hearing examiner may also opt to issue an administrative decision if there are no objections by the opposing party. This is rare. Usually the petitions go to a hearing, right? So the rent program hearing examiner examines evidence submitted in the petition and the opposing party's objections, and here's testimony from both sides. A decision to award a rent refund in order to reduce the rent generally occurs several weeks after the hearing is held. So once the hearing is held, the hearing examiner will issue their decision. Both parties may appeal the hearing examiner's decision within 35 days of the date of decision. So if either party does not agree with the decision made by the hearing examiner, they can appeal it and it'll go to the rent board. So the entire petition process takes anywhere from 6 to 10 weeks to get to a hearing. And then, in addition to that, waiting for the decision. So understand that this is another avenue that tenants have, and this might be, something that you would be involved with if the tenant believes that there are habitability issues and, like their implied warranty of habitability isn't being met in the unit. Okay, so another consequence, there are habitability problems and relocation payments. So in addition to the Richmond Rent Ordinance, there is also the Relocation Ordinance, and the Relocation Ordinance has temporary relocation payments. So under the Relocation Ordinance, if habitability problems are such that repairs and abatement require the tenant to temporarily relocate, the landlord must pay temporary relocation. And I feel like a lot of landlords usually feel like the relocation payments are really extreme. And I think an explanation is that the relocation payments are such that the situation is extreme, right? Like the habitability issue in the unit is so bad that the tenant cannot remain in the unit while it's being fixed, or the tenant has left due to health and safety issue, or there has been a governmental order. So an inspector has come in and said the tenant cannot live in this unit and the tenant has to vacate. And so it's important to understand that temporary or permanent relocation payments are usually awarded in extreme situations, right? So, but if the work to the rental unit does not get completed within 60 days, and regardless of whether the tenant received temporary relocation payments or elected to receive such payments, the landlord shall immediately make rent differential payments to the tenant under the tenant if the tenant reoccupies the unit, until the tenant reoccupies the unit. So there's different layers, right? The first 60 days, the landlord is responsible for paying temporary relocation payments. If it hasn't been completed, then it goes to rent differential payments. And then after a specific time, it can go to permanent relocation payments. So if the work to the rental unit does not get completed within 120 days, the landlord shall continue to make rent differential payments to the tenant until the tenant reoccupies the rental unit or finds alternative permanent housing. If the tenant finds permanent alternative housing, the landlord shall make a permanent relocation payment to the tenant in addition to other relocation payments or rent differential payments. So the relocation ordinance is really confusing and very complex, but I think it's important for owners to understand that if they are not maintaining a habitable unit, right, if they are not upholding the implied warranty of habitability, and it gets to the point where it's a health and safety issue for the tenant to remain in the unit, where the issues that need to be addressed in the unit are not safe for the tenant to live in the unit, or if a governmental order, right, so an inspector comes in and says, like, you need to leave, you can't stay here, the landlord will most likely be responsible for temporary relocation payments and maybe permanent relocation payments. And so it's important to understand that. And so we're going to go over the temporary relocation payments. They must be provided to the tenants when they must temporarily vacate in order for the landlord to undertake substantial repairs. It's also required for the notice of entitlement to relocation payment must be provided with the notice of termination of tenancy. So one of the just causes is temporarily vacate in order to undertake substantial repairs. And so this is referring to that process where the tenant cannot be in the unit because there needs to be substantial repairs made to the unit. And so the amount of relocation payment is determined by a resolution of the city council. So, the city council has decided those amounts and they are set amounts that the owner needs to follow. And so these are the 2020 temporary relocation payment amounts. They change every year based on inflation. So in January of 2021, there will be new amounts. So as you can see, the landlord will be responsible to pay the hotel or motel per day per household. There are meal expenses per day per person in the unit, laundry, and if the tenant has pets, there's also an allowance for pet relocation payment for pet accommodations per day per animal. So it's important to understand what the amounts are and one of the consequences if there are such habitability issues where the tenant can no longer be in the unit. So these are the temporary relocation payments. And these are the permanent relocation payments. And so these are a little bit different. They're determined by base amount and qualified tenant household. These are the owner move-in relocation payments. There's also withdraw from the rental market relocation payments and governmental order to vacate relocation payments, which the amounts are a little bit higher. So moving forward from the relocation payments, there's also habitability problems and evictions. And so habitability problems can be used as a defense to an eviction lawsuit. Also, retaliatory evictions are illegal. So if a rent-controlled unit is deteriorating and the owner is attempting to terminate the tenancy, a tenant may use the habitability problem as a defense to an eviction lawsuit. So even if there are other reasons why the landlord wants to evict the tenant can always use the habitability problems in the unit as a defense. So it's always recommended that the owner is in compliance, they're in compliance with the rent ordinance, that they're in compliance with state law before they attempt to evict the tenant, because there are different defenses that a tenant may have. Also, an attempt to evict the tenant on the basis of the tenant submitting a request for a housing inspection is generally considered retaliatory and therefore unlawful. So there's specific state law that prohibits landlords from trying to evict a tenant after they've requested something that they have the right to do. A housing inspection would be one of them. Again, back to documentation. So chronological documentation is key, specifically with evictions, right? So this is evictions is that you're going to be going in front of a judge. You will be presenting your case in front of a judge. So it is important to chronologically document your response and action taken for habitability problems that the tenant notified you about as failure to do so may show a pattern or effort on the part of the landlord to illegally force a tenant to move out or constructively evict the tenant. So that's why it's important to show documentation, the tenant's complaint, your response, and have all of that documented. Last is the landlord must be in compliance with the rent ordinance to evict. Right, so if a hearing examiner issues a decision to refund or reduce the rent until a habitability problem is fixed, and the landlord fails to issue the refund, reduce the rent, and fix the problem, a tenant may use the landlord's noncompliance as a defense to an eviction lawsuit. Right, so there's different avenues and different defenses that the tenant has regarding habitability, especially if they have already gone through the petition and the landlord has not complied with the decision from the hearing examiner, and the landlord is now trying to evict. Okay, so that wrapped up the eviction section. Now we're going to move forward with landlord entry and collecting rent. So it's important to understand that lawful landlord entry is governed by Civil Code 1954. So there's very specific reasons why a landlord can enter the property. So there is, in case of an emergency, to make necessary or agreed repairs, decorations, alterations, or improvements, supply necessary agreed services. There's also to exhibit the dwelling unit, for prospective purchasers or mortgagees. And lastly, there is the inspection required or pursuant to subdivision section 1950.5, which is a security deposit law. So tenants are also entitled to an inspection before they move out. It's also the landlord can enter when the tenant has abandoned or surrendered the premises if there's a court order. And then there's all these other legal sections. Essentially, there are very specific reasons why a landlord may enter the property. And so ensure that you are following Civil Code 1954 when entering the property. So the tips for lawful landlord entry: First is that landlords may not enter for general inspections. So I have seen in leases, or, you know, the landlord will send the tenant hasn't requested an inspection, the tenant hasn't said that there is anything wrong with the unit, but the landlord is saying, well, I want to enter just to enter. And so this isn't a reason that's allowed under Civil Code 1954. In addition, the landlord can't just stop by, right? Like, you as a landlord cannot just stop by and request to enter. The landlord must give the tenant a written notice to enter at least 24 hours prior to entry. And it has to be a written notice. The landlord does not need to provide written or verbal notice to enter to respond to an emergency, right? So there's a fire, flooding. If you see that your unit is on fire, you don't have to say, well, here's a 24-hour notice to enter. But under other circumstances, they do. Also, what's important is the tenant cannot demand that they be there when the landlord enters. So sometimes tenants get in situations where the landlord is going to enter during business hours, but the tenant says, no, you can't enter because I'm going to be at work. So the tenant cannot deny entry because they can't be there, right? The tenant is, if they want, they are allowed to be in the property when the landlord enters, but if they want to be available or they want to be there for the inspection, it's their responsibility to be available. So they can't deny the landlord entrance because they won't be there, right? So entry must be during normal business hours. And also the landlord must state the time and date as well as the purpose of the entry in the written notice. And so it's important to know that in Richmond, it is just cause to evict the tenant who denies a landlord lawful entry after the tenant has been warned to cease denying lawful access and continues to do so. And so when I see the situation is usually where the tenant is saying, no, I want to be there, I have to be there. But I'm not available during the times that you have to enter. And so it's important for the landlord to understand that they have to issue the written notice, and then the tenant cannot deny them entry. If they want to be there, it's their responsibility to make that a possibility, you know, for their schedule and availability. Okay, and so again, we're going over, right, the habitability problems and lawful landlord entry to make repairs. So the first 24-hour notice to enter is required. So if a tenant informs the landlord about the habitability problem, the landlord has an obligation to make necessary repairs. And so the landlord has the right to enter the rental unit to make repairs after giving the tenant at least 24 hours written notice. Be aware that abuse of the right to enter can lead to the rent being frozen for rent-controlled units. So a landlord may not abuse the right to enter and must follow specific rules laid out in Civil Code 1954. Abuse of the right to enter can lead to the landlord being unable to reset the rent to market when the tenant leaves. So the tenant does not need to be present for the landlord to lawfully enter. So this is what we just went over. A tenant has a right to be present during the inspection, but Civil Code 1954 does not give the tenant the right to deny entry because the tenant is unable to be present. And so again, denying the landlord entry can lead to a just cause to evict. So another important part of California law is withholding rent due to habitability problems. So this is another thing to be aware of. California Civil Code Section 1942 allows a tenant to pay for repairs and deduct those expenses from the next month's rent. It's usually referred to the repair and deduct method, right? But there are requirements and restrictions regarding this remedy, right? So the tenant must provide oral or written notice of dilapidations, rendering the premises untenable, which the landlord ought to repair, and the landlord neglected to do so. The tenant also has to provide oral and written notice and wait at least 30 days to determine if the landlord will remedy or repair the problems. It's sometimes shorter wait periods may be warranting depending on the circumstances of the problem. So sometimes if it's like an extreme situation, it might be reasonable for the tenant to wait less. And so the tenant may pay for the repairs so long as the repairs do not cost more than 1 month's rent, and they may deduct those expenses from the following rent due. The tenant may also choose to vacate the premises without any further obligation to pay rent. And so tenants may only use this remedy twice in a 12-month period. So this section is just, for informational purposes, but understand that if a tenant decides to withhold rent due to this law, landlords are encouraged to seek the advice of an attorney, because these usually are on a case-by-case basis, right? A lot of these issues are fact-specific and fact-based. And so a housing counselor is not going to be able to give you legal advice or, suggest what are the best steps for you to take or a strategy for you to take. So it's always encouraged for the landlord to consult with an attorney. Also, California law is a landlord's inability to collect rent due to habitability problems. So California Civil Code Section 1942.4 prevents a landlord from demanding rent, collecting rent, issuing a notice of a rent increase, or issuing a 3-day notice, now a 15-day notice to pay rent or quit, where all of the 4 factors exist. So the rental unit lacks any habitable characteristic as listed in Civil Code 1941.1, or violates the Health and Safety Code, or is deemed and declared substandard as explained in Health and Safety Code Section 17920.3, because the conditions listed in that section exist to the extent that endangers the life, limb, health, property, safety, or welfare of the public or the occupants. A public officer or an employee who is responsible for the enforcement of any housing law, after inspecting their unit, notifies the landlord or his or her agent in writing to abate the nuisance or repair the substandard condition. And the condition continues to exist without abatement for 35 days beyond the date of written notice provided by the public officer or employer responsible for enforcing housing laws. And last, the complaint of the condition was not caused by the tenant. So if all of these conditions are met, that's another kind of option that the tenant has, in order to withhold rent due to habitability problems. So these are cases that I often see. And again, these are contentious, like there are contention cases where the tenant is demanding or requesting that their habitability issues be addressed and the landlord hasn't addressed them. So the tenant is now withholding rent. And it's highly encouraged for you to consult with an attorney if the issue gets to this case, right? Especially if there's already been an inspection and the landlord hasn't complied with the request. Usually it's a notice of violation issued by an inspector. And so important to address, in addition, to being able to withhold rent, the habitability problems may lead to the landlord being unable to raise the rent. And so a hearing examiner may deny a landlord from taking a future vacancy rent increase if there is evidence that there was intent by the landlord to force a tenant out by not fixing problems. So under rent board regulations, if a tenant moves out of a controlled rental unit due to unabated habitability problems, the rent board may consider this a non-voluntary vacancy. And so if a tenant leaves as a result of the unabated habitability problems, the rent level of the next tenant remains at the same level that the tenant who was forced to vacate was paying. And so this kind of has to do why the landlord has a right to raise the market to rent. So under rent control, landlords have the right to raise the market back to the market level. One of the conditions is if all the tenants have voluntarily vacated out of the unit. In this example, it's argued, that the tenant did not leave voluntarily, that the habitability conditions were so extreme that the tenant can no longer remain in the property, and so they chose to leave due to unabated habitability problems. And therefore, it was not a voluntary vacancy, and the landlord does not have the right to raise the rent to market. And so be aware that that is a rent board regulation, and that is a decision that a hearing examiner can make. Also, another inability to raise the rent is if non-compliance with the hearing examiner's order can result in denial of future AGA increases. Right? So one of the things that the owner is entitled to under the ordinance is to raise the rent based on the annual general adjustment. So if the rent board hearing examiner orders the landlord to make repairs, to reduce the rent, or to refund rent overcharges, and the landlord fails to comply with the hearing examiner's decision, the hearing examiner may also deny the annual general rent adjustment increases until the landlord comes into compliance. And so that is also another mechanism that is available for rent controlled units. Okay, so lastly, we're going to go over breach of the lease agreement and the options for mediation. So there's lease breaking law, and you sometimes see this with habitability issues, as previously mentioned. Right, so if a tenant breaks a lease, they are liable for unpaid rent remaining on the lease, but only if, one, the landlord attempts to mitigate unpaid rent damages by making a reasonable effort to re-rent the unit. So in other words, if a tenant breaks a lease, the landlord cannot make the tenant pay for any of the remaining unpaid rent unless the landlord can show that they made a reasonable effort to re-rent and were still unable to find a replacement or new tenant for every month of rent allegedly owed. So even if a tenant breaks a lease, a landlord may not charge a tenant for all of the rent still due on the contract. For example, if a tenant breaks a lease 6 months in, a landlord cannot charge a tenant for the remaining 6 months of rent. A landlord may only charge rent as it becomes due, during which they must continue to make a reasonable effort to re-rent the unit. So this law right now is pretty popular, right? As some people are just saying, like, I lost my job, I can no longer pay the rent, or I can no longer afford to live in the Bay Area, but I have a fixed term lease. What are my options? And so it's important to be aware that there is a lease breaking law, and these are the requirements that the owner needs to follow. There's also the breaking of the lease as it relates to habitability problems. So significant habitability problems may allow a tenant to vacate without proper notice. And so if a tenant vacates a rental unit due to substantial and ongoing habitability problems, the law may allow them to end their tenancy without giving 30 days written notice. So if a tenant vacates the property and is sued by the landlord for unpaid rent, ultimately a tenant's right to vacate without provided notice would be decided in court. But understand that this is an option, or this is a possibility that can occur. Significant habitability problems may allow a tenant to break a lease without being liable for unpaid rent remaining on the lease, right? So if a tenant vacates their unit due to significant habitability problems, they may be allowed by law to vacate the unit without being liable for unpaid rent remaining on the fixed term lease. Because the argument is that the landlord implies or promises to comply with the implied warranty of habitability when they sign a lease agreement. And so the tenant may argue that the landlord breached the lease agreement by failing to follow the implied warranty of habitability. And so again, this all goes down to like that promise or that implied warranty of habitability, right? That is part of the agreement that a landlord has with the tenant, that the tenant holds their tenancy, and as part of that agreement, the landlord is making the promise of maintaining the implied warranty of habitability. Ultimately, liability for breaking a lease would be decided in court, right? So usually what occurs is the landlord will sue the tenant for any unpaid rent on the lease, and the tenant would have might have this argument saying, well, I left because there were severe habitability problems. These are all my documentation. This is the inspections that were done. And it would be up to a judge to decide. And so because each lease breaking situation is different, it is recommended that landlords consult with an attorney prior to taking any action. So understanding what are your rights, what are your responsibilities, you know, how strong is your case, and what are your options. One of the options that are available for habitability issues is mediation, right, which is an option to resolve habitability problems. And so either a landlord or a tenant may request mediation through the rent program to resolve habitability disputes. Mediation is currently informal because we're not working in the office, so it will most likely be done through the phone. But that is a service that's still available. So mediations can be scheduled within weeks, whereas the petition process can take several months. So a tenant may file a petition that takes, I don't know, 6 to 10 weeks, maybe longer, versus a mediation can be scheduled depending on the availability of staff and the availability of the landlord or tenant. Also, mediations are generally less adversarial in nature, and participants often improve their relationships due to better communication and understanding. So the mediation has to be voluntary, right? So both the landlord and tenant are agreeing to mediate and to discuss the issues. And so the mediation kind of gives them the opportunity to share, to discuss what the landlord's issue is, or what the tenant's issue is, what they want to be addressed. And it's kind of more of a decision to come to an agreement together, versus the petition is potentially the hearing examiner making a decision on the issues based on the facts of the case. And so the mediation is also an option, but it's also important to understand that it's voluntary, that both parties have to agree to be present, versus a petition is just someone filing the petition. And if it's complete, it would move forward even if the other parties don't respond. Okay, great. So I believe this is our last slide. Moving forward, we're going to go to our Q&A section. So if you have any questions, always feel free to contact the rent program. Our staff is currently working remotely, but we're still available to help you, right? So we're still available through phone and through email. You could also find a lot of our information on our website. So visit us at richmondrent.org. Moving forward, we're going to move forward to our Q&A session. So if you have any questions, please type it in the Q&A section in the Zoom, and Monica will read each question, and Palomar and myself will answer any questions moving forward.
Just as a quick addition or notice to everybody before or while people are writing their questions, earlier in the presentation, Magali mentioned the COVID-19 Tenant Relief Act under AB 3088. Just for your guys' information, next weekend, there's going to be another workshop regarding specifically the COVID-19 Tenant Relief Act. I will be hosting it. So if you would like to register and attend, please visit our website. It will be next weekend, Saturday at 10 a.m.
Okay, we currently don't have any questions in the queue, so we'll just wait a minute or so. And make sure when you ask a question to use the Q&A button there, not the chat button. Okay, we have a question here. Question is, what can you do if habitability issues are caused by tenants? For example, they have made changes to structures not approved.
So this is usually dependent on your lease, right? So if your lease says that the tenants cannot, and so that's why it's important to review your lease and what the stipulations under your lease agreement are. If your lease specifically says that tenants cannot make any changes to the property without the landlord's approval, then you're potentially looking at a breach of lease issue, right? So the first step would be to issue the tenant a written warning notice to cease. And so the written warning notice lets the tenant know that this can lead to an eviction, that they can contact the rent program. It lays out the steps that the tenant needs to follow to comply. It also lays out the details, witnesses, proof that the owner has to let the tenant know what the issue is, and potentially, that this is a breach of lease situation. So that is an option that the owner has. I don't know, Palomar, if you want to add anything. I have other questions, but to answer the general question.
Yeah, I mean, I think that this question actually has two separate issues, right? One is habitability issues caused by the tenant, and the other is changes to structures not approved. I think Magali is correct that you have to kind of look at the lease agreement to determine what is the rules and provisions regarding alterations to the unit. And that's not necessarily a habitability problem, right? Like if a tenant changes the locks, it's not necessarily a habitability issue, but it may be prohibited by the lease. Now, in terms of habitability problems, if they're caused by the tenant, I mean, on one hand, it kind of depends what the issue is. And also like what's, you know, how did the situation play out? Like if the tenant complains to the landlord, like, you know, I don't have heat or there's mold, but they were the ones who are taking 8 showers a day and who were not ventilating it properly or something, then, you know, kind of earlier, as Magali was saying, the responsibility is not necessarily on the landlord to, you know, make sure that that is, well, I take that back. It is their responsibility to take care of the problem, but then the liability in terms of the cost may fall on the tenant. And so ultimately, habitability problems just generally always fall on the part of the landlord. But there is kind of a caveat to that, in that if it is in fact, you know, a landlord, or excuse me, a tenant's fault, then it's possible they could be charged for it. Like if, and I want to make a clear distinction here. I mean, you know, a tenant just using their facilities as they normally should and something happens, that's different than them like negligently or intentionally causing something to happen or occur. Like they are intentionally stuffing stuff down the sink or the toilet. You know, that's a separate matter than them just using it, you know, regularly, and then it just happens to, you know, get clogged or something. And so really habitability problems are really fact specific. Each one is different, each house is different, each apartment is different. And so therefore the analysis is so like specific and unique to each situation that you really do have to kind of look at the facts and see like what's going on before you make any decisions. But I encourage any landlords to contact our program to discuss with, you know, anyone of the housing counselors or even myself to, you know, discuss, you know, what your potential options may be.
Okay, great. We have another question here in the queue. Question is, what can a landlord do when we are concerned about habitability due to hoarding or fire hazards due to clutter?
So again, under the rent ordinance, the landlord's main or one of the tools for enforcement is the written warning notice, right? So depending on their stipulations of the lease. So if the landlord believes that the tenant is breaching the lease or they're causing a nuisance, the main mechanism for enforcement is going to be a written warning notice, right? To let the tenant know, like, you're potentially breaching your lease, you're potentially causing a nuisance. These are the steps that you need to take to correct those violations. Otherwise, there may be a potential eviction, right? So letting the tenant know that they may be putting their tenancy at risk. The other option that the landlord has, especially for hoarding or fire hazards, right? This is where the inspection program would come in. So they can always request an inspection with the residential rental inspection program. If there are issues or if there are concerns for fire hazards, there's also the fire prevention services that's ran through the fire department. So that is also another resource that the landlord can contact. And so I do know that fire prevention services will go out and, you know, make any notes or issue any changes that need to occur in the property if there are fire hazards, or if you know, things are being blocked and it doesn't allow for proper escape in case of a fire. So those are the two departments that can actually go out and inspect the unit, and if there's issues with hoarding or if there is just something that is like blocking a fire escape, is the fire prevention services department, which is ran through the fire department, and the residential rental inspection program, which is ran through the planning and building department.
Yeah, I just want to quickly add to, so, you know, just as a kind of a qualifier for hoarding, I mean, hoarding in and of itself is not a problem. It's not illegal for someone to do that. And in fact, it's been classified as somewhat of a mental health illness. So there are added complications for hoarding. That said, hoarding can lead to fire hazards, and it can lead to other issues such as like, harboring of rodents or roaches or mold or whatever. And so there is obviously a concern there. But then you have to really kind of determine, like, well, is that in fact happening? Are there in fact fire hazards? Are there in fact, or is this hoarding situation actually causing habitability concerns, and that could endanger the health and safety of the tenant? That's what the landlord has to find out first. And then also, as a related point, and I want to make this, during Magali's presentation, she was talking about landlord entry. Landlords should also understand that currently, due to the COVID-19 pandemic, the state of California has issued guidelines for persons involved in residential real property transactions. And so there are guidelines now that landlords have to abide by in order to enter into a tenant's unit. And that includes, entering for habitability problems, that includes showing the unit. These guidelines are posted on the California State website, and they specifically talk about, like, you always have to wear masks, you can't touch things that you don't really have to, you have to avoid going to places where you don't need to. The guidelines and rules have to be posted outside the tenant's door, and every person entering has to sign something to say that they understand these rules. So that's just an added thing that landlords should be aware of currently during this pandemic.
Okay. We have some more questions coming in. Our next question is, I bought a fourplex, but the tenants changed the locks, so I don't have keys for the units. Are they allowed to do that?
I think Palomar might have to answer this question. My understanding is what's depending on your lease, what the lease stipulates and what the lease allows for. I don't know, Palomar, if.
Yeah, that's correct. I mean, first of all, yes, there's usually like an alterations clause in most form standard leases, and so you should check the lease. But also, it's kind of impliedly understood that landlords should have access and keys to the tenant's unit, because one of the laws that Magali mentioned earlier, California Civil Code 1954, says that a landlord can enter for emergencies. But obviously that's somewhat difficult and nearly impossible if they don't have the keys. Like, a landlord is, how are they going to get in? Are they expected to break down the door? Probably not, right? So it's kind of understood that landlords are supposed to have access and keys to the unit in cases of emergency. And so if this is happening, one, you should check the lease, and two, you should issue a letter to them, kind of, letting the tenant know that this is kind of your right, that in case of emergency, I will have no access, so therefore I need to have access to this unit. And, then you can go from there.
Okay, thank you. Next question is, I guess they're asking if it's a habitability issue, a storing of unoperated vehicles in the backyard, and parking trucks in the backyard.
Is a question storing of unoperated vehicles in the backyard and parking trucks in the backyard? Is that the
Correct.
question?
Yeah.
So a lot of this issue is dependent on your lease. It's what your lease stipulates of how the tenant can utilize the property and what it is that they can and cannot store in the backyard. I do know that code enforcement goes out and, like, if there are specific concerns or issues with unoperable vehicles. I'm not aware of the local law. I do know that I have had cases before where code enforcement has gone out. It's important to know, though, that because you are the owner, if a violation is issued, it's going to be the owner's responsibility. So if a fine is issued because of an inoperable vehicle, it's going to be the owner's responsibility, right? And then after that, it's the owner's responsibility to enforce that violation, or to sue the tenant through small claims court because of the fee. So I do know that code enforcement gets involved when there are issues of inoperable vehicles or trucks, if it is a city violation. But it's also going to be dependent on stipulations in your lease. If your lease doesn't allow for inoperable, or sometimes, if you don't move the vehicle, or if it's not properly registered with the state of California. So those are the two things.
Yeah, I agree with what Magali is saying, and definitely check the lease. As I said earlier, I mean, each case is kind of different. It depends, like, how long it's been there. Is it in fact inoperable? And and plus, I think Magali's right too, that you should reach out to the code enforcement or the inspector's department, or you can reach out to us so we can send a referral to them in order to find out, like, what is the law regarding these things, and is there, because I know I used to work for the city of Berkeley, and they had particular laws regarding blight on a property, and one of those things was inoperable vehicles in the yard. So I don't know for sure, if I'm not 100% sure if Richmond has the same type of law, but it's always good to ask the people most knowledgeable with these kinds of matters, and so that would be the code enforcement or the the inspectors unit.
Okay. Next question is, how do I know if an issue is a habitability issue? I'm going to give an example. The stair treads are built with bull noses on top. There is a gap. Stepping on bull noses is uncomfortable. I'm feeling pain with carrying some weight walking down the 16 stair steps.
Yeah, I mean, I think this is kind of similar to my last response. I mean, it's hard for anybody to really know for sure unless you're an expert in the matter, or it's just 100% obvious. If there's rats all over the place, that's clearly a habitability problem. Anybody would know that. But whether or not stairs are in compliant with the law, there's Health and Safety Code 17920.3 specifically talks about, like, stairways, talks about weather, outside weather protection. It talks about foundations, a lot of different stuff. And so it's not necessarily your job to make that determination, but it is your job to follow up and see, like, well, who can find out? Let me reach out to these people. Let me reach out to the city. Let me get an inspection. That's kind of the way to do it. And also to continue to document the problem by, taking pictures and, like, looking at the, what are the safety concerns? Have the tenants complained? I mean, these are all various issues that, you need to kind of follow up with. And that's really the responsibility of the landlord. It's not to necessarily make that determination on their own every time, but it is on them to kind of follow up and try to, to the best of their knowledge, do their due diligence, reach out to the people who would be most knowledgeable. I'm not sure if Magali wanted to add anything.
No, I mean, I think the best person, right, would be an inspector, so they're aware of local and state code and law, and so an inspector will go out and view the stairs and know if it's in compliance.
Okay. Next question is, what are the rent program laws and housing laws around the amount of people that live in a one-bedroom unit? For example, if the unit originally allowed for 3 people, but now there are significantly more than were not originally on contract, what recourse do landlords have?
So this question is a little bit complicated. I think the first section of it is what are the laws around how many people can live in the unit? And so the city of Richmond follows Uniform Housing Code 503B. So it's not as straightforward as 1 bedroom, 2 bedroom. It determines the livable square footage of a unit. So this usually is the bedroom and the living room. It doesn't count the kitchen, the bathroom, hallways, or closets. So you would, as a landlord, you would need to measure how big, how much square footage there is in your unit, and deduct the square footage and, kind of keep the livable square footage, which is usually the bedrooms and the living room. And then from there, it's a little fuzzy in my head. I think it's 70 square feet, 70 livable square feet for 2 people. And for every additional person, it's 50 square feet. I am not 100% sure that that is the right square footage. I'm pretty sure, but it's Uniform Housing Code 503B. And so that's the code that the city follows, and also the code that's stipulated in the Richmond Landlords. And so to really know how many people are allowed in your unit as an owner, you would need to measure the unit and know how many livable square footage there is. And so the second part of that question was the lease allows for 3 people, but then now there are significantly more than there were not originally in the contract with recourse. So the first step is to know who are the people living there. Are they friends? Are they nuclear family members? Because there are protections under the rent ordinance, under state and federal housing law, right? So like if the contract originally allowed for 3 people and it was, you know, husband and wife, and they had 1 child, and then they had a kid, and so now there's a 4th kid, you can't attempt to evict because that couple had a baby. And so there are protections under the rent ordinance that protects nuclear family members. And so I think the first step is important to understand who are the people that are living there. Some of the recourse, right? So like if you're like, now there's, I don't know, 5, 6 people living there, and then none of them are family members. One option is, right, breach of the lease. The second option is if it is a rent-controlled unit, you could file a petition for additional occupants. So the rent ordinance does allow for petitioning the rent board for a rent increase if there are additional occupants. However, there are specific stipulations that protects family members. So I would recommend that you contact a housing counselor so you can go over the facts and the details of the case specifically. In addition, I do believe that right now, due to the pandemic, Contra Costa County has some additional protections for eviction. So let's say like a family member was evicted from their other unit due to the pandemic, and they moved in with that person. There are also protections due to the pandemic that prohibit eviction for additional people in the unit. And so that's something else that you would need to look into, just because I think the priority of many officials and laws right now is to keep people sheltered during the pandemic. And so there are various protections without the pandemic, and then there's currently additional protections under the Contra Costa County ordinance.
Yeah, that's right. You know, these situations are more complicated because of the pandemic, and the Contra Costa County ordinance states that through January 31st, 2021, a landlord shall not terminate a residential tenancy on the basis of a tenant allowing an unauthorized occupant to live in the dwelling unit if the occupant is a member of the tenant's immediate family living in the dwelling unit as a result of the COVID-19 pandemic. There's some kind of unclear terms there, like what does immediate family mean as a result of the pandemic? I mean, it's kind of unclear. They don't really specify. But, you know, just be aware that that law currently is still in place until January 31st, 2021.
Okay. Next question is, in my property, there's a washroom, but it's not stipulated in the lease. Can I remove the use of it?
I think it depends, right? So it depends on the facts of the case. These are situations where sometimes a service is not strictly stipulated in the lease, but the tenant can argue that it is part of the lease because they have had use of it since they moved into the property, right? So like if a tenant moved into the unit and they've had access to this washroom for 5-10 years, and even though it's not in the lease, now you want to remove it, the tenant has the argument to say like, well, I've always had access to the service. This has always been a service that has been provided to me. And now that service is being removed. And so if it is a rent controlled unit, they can petition for a reduction in services. So that's kind of what I have to say about that. Obviously, it's dependent on the facts of the case.
I think Magali is right. Things that are not necessarily explicitly stated in a lease can become part of it, because things that are implied in a lease are also become part of it. So for example, if you rent to a tenant and you have a lease agreement, and then you just tell them verbally, oh, by the way, there's a washroom and you can use it. And then they start using it. And as Magali said, it goes on for some time or whatever, it's part of the lease now. And therefore, if you remove it, they have a right, again, if they're rent controlled, they have a right to petition the rent program to reduce their rent based on the reduction in services.
Great. Okay, next question is, may I know what the process is to get an inspector?
Yeah, so I mean, there's two options. One, you can contact the residential rental inspection program yourself. So the email and number is in the slides. So you can reach out to them and request an inspection. The other is to contact the rent program, and the rent program can send an email directly to building and planning department and kind of lay out the details of the case and why you're requesting an inspection, and they'll reach out to you. Those are the main two avenues.
Okay. Oh, we just got one more question. Next is, are landlords allowed to issue new lease documents for existing tenants, especially an existing lease agreement that was signed several years ago, and now there's a newer language and codes that have been incorporated in current lease forms? For example, prohibiting short-term renting.
So the answer, is an owner cannot unilaterally issue a new lease. So if the tenant wants to sign a new lease and they agree to that new lease, of course, then you can both agree to new leases. But the owner cannot simply say, oh, there are new laws, there are different things that I want to change about the lease, here is your new lease and you have to sign it. So for example, there are a lot of cases that I have where tenants, they were on a fixed term lease their first year, they have now been there for 10 years and they've been month to month now for 9 years. And so the owner says, I want to renew the lease. I want to, change the clauses, to no pets, where the previous lease allowed for pets. So the owner can't do that, right? The owner can't change stipulations in the lease. The tenancy is established under the original contract, and that is the right that the tenant has to remain under that contract. However, if both parties, if both the tenant and the landlord agree to the new lease, then that is something that can be done, but the owner cannot unilaterally make changes to a new lease and enforce a new lease.
Right.
That makes sense. Sometimes.
I'm sorry, go ahead.
No, sometimes I don't know if I'm answering the question.
No, yeah, I think you said it right. I think landlords can offer, but making them is different, right? You can tell, hey, I want to update our lease. It's been 10 years, there's new laws and all this stuff. And, but part of our ordinance specifically says that a landlord has to tell the tenant for any new terms, if they want to make it enforceable, they have to tell when it's offered during the tenancy, not at the beginning, but during the tenancy, that they don't have to accept these terms. That's part of the ordinance. So it's required that you inform them. You don't have to sign this, and you don't have to, but you can if you want to. And and as Magali said, if they choose to, then yes, it's enforceable now. But they could just as easily say, nope, I don't want to do that. I'm sticking to my original lease agreement. And so, yeah, that's a very good question. It is, and that's the other thing too, is that the reason that you can't force them is because it's not a just cause to evict a tenant for failure to sign a new lease agreement. Berkeley has a similar kind of law where it says, like, if a landlord offers a substantially identical lease upon expiration of the previous one, then, and the tenant refuses to sign, then that's a just cause. But Richmond doesn't have that just cause. So it's not a just cause under our ordinance.
Okay, that was the last question for now. We can wait a couple of minutes. Oh, one more. Next question is, can the landlord ask for payment after fixing the issues?
So I have to make a few assumptions with this question. I'm guessing that the landlord is saying that they have addressed habitability issues, which the tenant were responsible for, and now the landlord is asking for payment. Right. So right, that's what they're saying. Assume that it's the tenant's fault. Yeah. So the owner can always write a letter to the tenant saying, I'm requesting payment, right? Like if I don't know, like the tenant broke a window and the tenant lets the owner know, like, hey, there's a habitability issue. The window is broken and I need you to fix it. The owner fixes the window, but now the owner issues a letter telling the tenant, no, well, this habitability issue was caused by you because you broke the window. And so it cost me X amount of dollars to repair it. So you can always request that the tenant pay that. I think landlords kind of run into the issue of the enforcement mechanism, right? So if the tenant says, well, yeah, this was my fault, but I'm not paying for it, then what options does the landlord have, right? So one would be to, I believe, taking that as security deposit, which would occur after the tenant vacates the unit. And the other option would be to sue the tenant in small claims court if the expense of the issue that you fix is worth for you to go to small claims court over. And so I think those are the main two enforcement mechanisms. So yes, you can issue, a letter or a notice. And then if the tenant doesn't pay, what are your enforcement mechanisms?
Yeah, that's right. I just want to add on real quick that, you cannot, try to evict the tenant for failure to reimburse you for those issues in and of itself. I mean, if the tenant did in fact cause problems, that's a different theory. That would potentially be like nuisance or something, or breach of lease. But you cannot evict the tenant simply because they didn't reimburse you. You'd have to use one of the options that Magali laid out, either deduct it from the deposit once the tenant vacates, or attempt to take a claim in small claims court.
Okay. Next question is, are tenants allowed to use areas as living areas as a bedroom that were not allowed to be used as such? For example, a garage as a bedroom.
I think this question is a little difficult, and I mean, somewhat outside of the scope of the rent ordinance. So Palomar, if you want to answer it. I mean, I do have the understanding that I believe it's Civil Code 1941.1 or Civil Code 1941.2, right? That says that it is a tenant's responsibility to utilize a room at its intent, right? So they can't use the living room as a kitchen, or I think stuff for that matter. But I also think it's the owner has to make that determination or kind of have the facts of the case. So how are you coming with this information? How are you aware that the tenant is using the unit or the bedroom not as a bedroom or a garage as a bedroom, and have proof and documentation and evidence? But I'll let Palomar answer that one because I think it's a little bit more complex.
Yeah, I mean, it is. Yeah, it's kind of complicated. I mean, I think there are laws that specifically say, like, you have to use certain areas as they're intended to be used for. However, I've never really seen an eviction or an unlawful detainer filed simply based on these laws. Usually what it is it's the lease agreement. And so for a landlord who's alleging that the tenant is using, a garage as a bedroom or something, they should check, look at the lease, determine if there's any provisions talking about, use and occupancy, and also alterations to the unit, that kind of thing. Those are more substantial and kind of solid arguments, as opposed to saying, well, there's this kind of floating law that says you're only allowed to use it. I mean, I guess it's an argument, but I've never really seen it kind of go through in court. You may just want to reach out to an attorney to determine, but like I said, the first step is just to look at the lease agreement, and also, as Magali said, to determine the facts first, to make sure that you are, your allegations are in fact correct.
Okay, we don't have any questions right now, so we'll wait a couple minutes. Okay, we have a question that came in. Next question is doors. Hold on a moment. Do single family home tenants issue rent increase? I think they're asking if rent increases for single family homes are issued. If they're issued, do they go to the rent board?
So single family homes is a term that the rent program doesn't really like, because I think it's a little bit confusing. So the city of, or in Richmond, there are a lot of properties that have that are considered single family homes, right? So like on the county records, it'll say single family home SFH. But in reality, the property has been, or the house has been subdivided, or there have been there's like the garage has been converted, or there has been an ADU that has been added. So that sometimes changes the way that the rent ordinance impacts the property. So if there is only one dwelling unit on the property, if there's only one living unit on the property, and therefore the property is not under rent control, then any rent increases that are issued do not have to be submitted to the rent program, and the owner simply needs to follow Civil Code 827, which is noticing requirements. If it's less than a 10% increase, it's a 30-day notice. If it's more than a 10% increase, it's a 90-day notice. However, there are situations where the owner believes it's a single family home, but because it's subdivided or there is an additional dwelling unit on the property, it can fall under rent control. And if it falls under rent control, then the owner is required to submit a rent increase notice with the rent program. So I think an answer to this question is, if the property is under rent control, then the owner does have to submit a notice of rent increase to the rent program and follow state law. If it's not under rent control, if it's only partially covered, then they are not required to submit any rent increase notices to the rent program.
Great. Okay. Next question is, can a renter use the rental unit as a business address and conduct business in the unit?
Ooh, I don't know. I think it depends on what type of business. Yeah, I don't know the answer to this question. I would have to do more research on it.
I can go at it. So yeah, I think Magali's right. It does depend on what you mean by conducting business. You know, first of all, even prior to the pandemic, you know, people were using their house, you know, like if you work for a tech company or something like that, or some place where you can work remotely, you know, is that conducting business? I don't know. That's a difficult question to ask. So it does depend on the business, you know, that you're alleging that they're doing, as opposed to like they rent a unit and a house and all they do is fix their cars. They don't even live there. That's totally different. Or if there's just a bunch of traffic going in and out of the property because of the business, that's again different than someone just working from home. And especially now with the pandemic, I mean, this is almost every type of industry is now essentially, you know, a lot of people are just now working from home. And so, you know, even myself, like I work from home. Is that conducting business and am I in violation of my lease? No, I don't think so, because I'm just working from home because it's mandated by current law, right? I can't prohibit it from going into our offices because of social distancing requirements and the current COVID-19 pandemic. And plus, the final point is that you have to look at the lease. You know, does the lease prohibit the use of the residence as a business? If it does, and they are in fact using it as a quote unquote business, then, you know, you may have a just cause to evict. But it's highly encouraged to speak to a lawyer and to also determine the facts. I mean, it just really depends on what the business is, and if in fact the person is, you know, quote unquote conducting business there. Is that a result of them just choosing to, or is a result of the pandemic? And so those are complicated issues that you should probably talk to a lawyer about.
Okay, that was the last question on the list. Oh, no, one more question. If a single family home with an additional illegal ADU unit, however, the landlord just rented out the whole place to one lease and with one family, is it considered under rent control?
So, I mean, it's going to depend on the facts of the case, and it's going to be up to the hearing examiner to determine. But potentially, yes, it could fall under rent control, right? So it's the same thing if I had a duplex and I rented out the duplex to one family. What determines if a property is under rent control or not is how many units are on the property and if it was built before 1995. So if there is more than one dwelling unit on the property and it was built before 1995, then it potentially does fall under rent control. Of course, like the tenant would have to file a petition, or the owner would have to request an administrative determination. And so it would be up to senior staff or the hearing examiner to look over the facts of the case and make that determination.
Yeah, these cases are complicated, right? And it's not we don't have the authority to make that determination based on this like one small fact pattern. It really does depend on the facts. But as Magali is saying, we look at, you know, how many units, right? It doesn't matter if we usually look at it. It's like, it doesn't matter if you rent it to one family. Could you have rented it to two? Probably it's 2 units then, you know? So just by the facts the mere fact that you rented it to one family is not determinative in and of itself. And so the proper process would have to be either one, like Magali said, the tenant would, you know, say, well, I think I'm under rent control, and they file a petition to determine. Or the landlord says, I don't think this is under rent control. I want the rent program to make a determination. They would have to submit the administrative request, determination of, I always get the title. Anyway, they have to submit that request, and then we can make that determination based on the facts and what you submit as evidence.
Great, thank you. and the next question we have is, are there any attorney resources that the rent program is familiar with that are specific for landlords?
Yeah, so major one is the Contra Costa County Board, Contra Costa County Bar. They have a referral services, and they also have the Contra Costa County also has like a moderate means program. So that's a major one for like landlords to contact, and they'll refer you out to an attorney. Because the rent program is a public agency, we cannot make referrals to any private attorneys. There's also Bay Area Legal Aid. Bay Area Legal Aid does provide general legal assistance. However, I do know that with the pandemic, their resources are more limited. So I'm not sure if they're currently providing assistance to landlords, but that previously has also been an option for landlords to contact.
Yeah, the Contra Costa County Bar Association is a good start. Although they're not, this question says specific for landlords. That's not really what the Bar Association is not specific for landlords. They just have general attorneys, and they will assign you to an attorney who does do landlord-tenant law, right? That kind of thing.
I don't think we have any resources that are specific for landlords.
Right. And so if you wanted something specific for landlord, you have to, find an attorney who does specifically landlord work, like only for landlords, or maybe they do for landlord and tenant, but they also offer those landlord services. Those are pretty prevalent actually in the Bay Area. And if you are looking for an attorney, it's pretty simple to find. You don't need someone who's like specific only in Richmond and they work in Richmond only, or they're only, you just need someone who has experience in landlord-tenant law. That's it. And so, there are plenty of firms in San Francisco that specifically help out landlords and represent landlords. And so you can find them pretty easily on like Google or on the internet.
We have no open questions right now. We'll give it a couple minutes again and see if any come up. We'll give it one more minute and see if any other questions pop up.
Yeah, and if we don't get to your questions, or you're still considering like what to ask, or you have questions after we end, our offices are still available. You can call us, you can email us, and we can, contact you directly.
Okay, so we have a question that did come up. The question is, if a tenant faucet drain is slow, is it a landlord's responsibility to repair it?
I mean, I think this is a question where it requires expertise, right? That we can't possibly answer without someone going out there and viewing the faucet. So is a faucet broken, or is it so slow draining that it becomes a habitability issue? Then yes, it would be the landlord's responsibility to repair. But I think that's where an inspector will go out and see if it's an issue where it's not complying with state or local law. I don't know, Palomar.
Yeah, I think it just depends. Responsibility is very fact specific. As I said earlier, and as Magali mentioned earlier too, generally speaking, if a tenant is just using their unit and the facilities that are inside of it as they, normally should, then it's, it cannot be the tenant's fault. It's just impossible, right? Normal use, and something happens that gets clogged, or there's the toilet backup, and they're just using it as they regularly were, as any normal person would. And I understand there's some, wiggle room there, what that means, but still, then it's not generally going to be the tenant's responsibility. It's generally the landlord's responsibility, because there are laws specifically and explicitly saying, landlord, you are responsible for this unless the tenant, caused it. But as I said before, just regular normal use of facilities, it's generally not going to be the tenant's fault.
Okay, that was the last question. So it's 11:48. Do we want to give it another minute or so?
Yeah, we'll give it one more minute.
Okay. The question that popped up is, where can we download or view this webinar again? I can actually answer that question. So this webinar is actually being recorded as we speak, and it takes about a day or two, 1 or 2 business days, for the video to be uploaded on our website, which is richmondrent.org/workshops. And you would just go down the list and find the title of this workshop, and you will be able to watch the webinar again.
I just wanted to add to that you can find all our workshops, right? So we have monthly workshops on eviction, rent control. Next week will be the AB 3088. So you can find all of our workshops and presentations on the link that Monica mentioned.
You can give it about a minute. Okay, it doesn't seem like we have any other questions coming up. Do you guys have anything to add?
I was just going to say thank you for attending, everybody. And, as always, we are here to help. So if you have any further questions after the presentation, feel free to send us an email or give us a call at our office line, and you can visit our website for the workshop information, as well as other related information to current law.
Okay, great. Thank you, everybody. Enjoy your weekend.
Take care.
Bye.